as it does, I think, for me with all legislation, because I use the Skip Bowie standard, who is an electrician in my town. He says, Ned, please don't vote for anything until you figure out if it's really needed. And right now, I don't think this is needed, because I think it's working pretty well. And when I listened to the testimony that we had over in Representatives Hall, the question is, what would people do differently than they're doing right now? And I heard from a lot of very wonderful people who are out in front of the facilities that we're discussing, who are doing their very best to counsel people if they have the opportunity to communicate with people, to do those things. But the question is, what would they do differently? And I'm not sure that they would do anything differently. I mean, they're still going to be, as from what I can see, for the most part, courteous people doing their job. So, long and the short is, I think keeping a buffer to prevent unwanted communications makes sense to me, and I'm going to vote against the bill itself and for the ITL. Representative Alexander?
Sorry, Mr. Chair, one more thing. The question behind this is proponents for the repeal of this buffer zone would say it's unconstitutional. Advocates for the buffer zone would say we've never used it because for one reason or another. My question is let's see if it's used, let's file a lawsuit and let's have the courts determine whether this is constitutional or not. It's been struck down in other states, so I would say like until the buffer zone is used, there's really no need to repeal it at this point. Thank you.
Any other questions or comments? Mr. Clerk, you want to call the roll?
On the question of House Bill 1625 being inexpedient to legislate, Representative McLean,
No.
Representative Sylvia,
No.
Representative Walper votes no. Representative Alexander?
Yes.
Representative Green? No. Representative Nodder? No. Representative Murner?
No.
Representative Kelly? No. Representative Doucette?
No.
Representative Andrus?
No.
Representative Smith?
Yes.
Representative Almy? Representative Horrigan?
Yes.
Representative DiLorenzo?
Yes.
Representative Chase?
Yes.
Representative Kenny?
Yes.
Representative Langley?
Yes.
Representative Macbeth?
Yes.
Representative Page? Yes. Representative Simpson?
Yes.
Mr. Chairman?
Yes.
2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. I have it at 12 in the affirmative, 9 in the negative.
We've adopted the recommendation of inexpedient to legislate. Representative Page, you need to do the majority report, and Representative McLean, will you do a minority report?
Yes.
House Bill 1673, an act relative to women's health, privacy, and repealing the Fetal Health Protection Act. Representative Wolper, would you like to make a motion?
Thank you, Mr. Chairman. I would move ought to pass as amended on House Bill 1673 with Amendment 0688H.
Oh, 0688.
Yes, 0688.
And is that seconded?
I can second it, Mr. Chair.
Seconded by Representative Alexander. It's supposed to be you.
Yeah, that's okay. You got it.
Okay, and do you want to address your amendment?
Thank you, Mr. Chairman. Mr. Chairman, the Fetal Life Protection Act has only been in effect for a couple of months, but it's been under attack ever since the day it passed, or even before. The major objection that's been expressed about this act is the requirement for an ultrasound for all abortions. But even though the act is constructed in such a way that it looks like that, it doesn't do that, because but in any event, in order to obviate that objection, I offer this amendment, which specifically says in the same paragraph that imposes the ultrasound, this subdivision shall be construed to require the performance of an ultrasound only if the provider either knows that the fetus has a gestational age of 24 weeks or is conscious of a substantial risk that the fetus has a gestational age of 24 weeks. So, to add to the compromise that the Fetal Life Protection Act already is, this language clarifies that the major objection that's been expressed ever since it passed isn't valid, or it has no strength.
Okay. So as I understand it, this replaces the entire bill with the provision with regard to the ultrasound, is that correct?
It does replace the entire bill with this provision of the ultrasound, yes.
Questions or comments? Representative Alexander.
Thank you, Mr. Chair, and I appreciate Representative Welper for bringing forward this amendment. This addresses my major concern that I had regarding the ultrasound mandate in September. I would say that this goes a long way to clarify the mandate. It also an ultrasound at knowingly at least 24 weeks is not a transvaginal ultrasound. A standard medical procedure would be a typical belly rub, non-invasive. I appreciate you bringing forward this amendment, and it addresses concerns. I think it helps clarify and strengthen the Modest Fetal Life Protection Act. Thank you.
All right. Other questions or comments? I just want to say I would not support the original bill, which in effect repealed the Fetal Health Protection Act, but I believe that that act is subject to some qualification, and this being one of them, and would support your amendment, but would support other qualifications as well. So. Any other discussion? Seeing none, we'll take a vote on your amendment.
On the adoption of Amendment 0688H to House Bill 1673, Representative McLean.
Yes.
Representative Sylvia.
Yes.
Representative Welper votes yes. Representative Alexander.
Yes.
Representative Green.
Yes.
Representative Nodder.
Yes.
Representative Murner.
Yes.
Representative Kelly. Yes. I get the wrong sheet. Representative Doucette.
Yes.
Representative Andrus.
Yes.
Representative Smith.
Yes.
Representative Almy. Representative Horrigan.
Yes.
Representative DiLorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
I have it 21 in the affirmative, 0 in the negative.
Okay, we have adopted Amendment 0688, and we are now open to further amendment. Representative Smith.
Thank you very much, Mr. Chair. I would like to move OTPA on Amendment 0730H.
And is that seconded? Representative Simpson seconds it. And would you like to address your amendment?
Thank you very much, Mr. Chair. I would. And I have to address my amendment by beginning first to say my heartfelt thank you to my colleague, the clerk of this committee. The clerk of the committee listened carefully to testimony that was difficult for all of us to sit through. And he did hear and come to understand the ambiguity, the perceived ambiguity in the language having to do with the ultrasound. I believe that the language that was passed quite inappropriately and without any hearing and without any deliberation in the Finance Committee to add inappropriately to House Bill 2 language that had nothing to do with the budget, that language was very vague, and it was perfectly understandable that reading that language would cause anyone to believe that an ultrasound examination, including an intrauterine ultrasound examination, was going to be required for anyone in this state undergoing a legal abortion. Remember, none of this applies at all to illegal abortions that go on in back alleys. And my hope is that we do everything we can to eliminate those. Representative Welper's suggestion was, I thought, appropriate, and while left to my own device, I might not include the 24 weeks. The 24-week restriction is not unreasonable. At least one, and maybe all, I don't know because I haven't done all the research, but at least one of the major legal licensed entities that provide a whole range of services, only one of which is abortions, they do not provide abortions after 16 weeks. 16 weeks is roughly 4 months. So certainly 24 weeks is not inappropriate. And I thank the representative for his amendment. I was very happy to be able to vote for it. But I see that as a floor, not as a ceiling. There are a couple of other items that were included in House Bill 2 that I also think are deserving of elimination. They basically come down generally to my consistently held belief that the legislature has no business in the doctor's office, that these decisions should be made by the woman and those people who she chooses to involve, including the medical professionals and her family, her religious, whomever else. But if in fact we are going to involve ourselves in these issues, then I think we have to make sure that we recognize that we have to have some other limits. The first change that I want to include is one having to do with fetal anomalies incompatible with life. And I believe that that is something that we should acknowledge. It happens. It doesn't happen always. It doesn't happen universally. But when it does happen, it is an incredibly painful circumstance and difficult new reality for someone who is pregnant and who has looked forward to having a baby and everything that comes from that. I, of course, know that the most important thing that comes from pregnancies and babies is that they grow up and they marry and they produce grandchildren, and nothing is more important than grandchildren. So I believe in those pregnancies going on. But sometimes there are fetal anomalies. Those are not something that the legislature can decide. That is something that a medical professional can decide with whatever additional help they need. So I would like to add, and as is added in my amendment, line 10, except in the cases of a case of fetal anomalies incompatible with life. That's one change. The next change that I wanted to make was to include in line 29 not just the life of the pregnant woman, but also her health. So it reads, the life or health of the pregnant woman whose life is endangered by, and then go on. And I think that health is a very important addition. And so there are two changes that I want to make. The next changes that I want to make in House Bill 2, where none of this belonged in the first place, is to remove the criminal penalties against healthcare providers and the civil penalties against healthcare providers. Healthcare providers are licensed by the state. There are standards that they must meet. There are provisions, whether they're setting the bones in my arm or my leg, or whether they're obstetricians are involved or gynecologists involved in delivering care for pregnant women. We are talking about people where we recognize the obligation of the state to license and the opportunity of the public, whether it be the patient or anyone else, to question the responsibility, the decisions that are made. All of that is already in law. To add criminal penalties having to do with whether or not, or having to do with how they function in cases dealing with pregnant women, I think creates a chilling environment. We have enough problems in this state, and we see it all over the state, not only in rural areas but also in urban areas, in attracting qualified, trained, licensed medical professionals to come and do their jobs. And we expect to hold them accountable to the standards that exist in this state. And I have no problem with that. What I do have a problem with is creating the appearance that somehow how they perform in this area differs from the standards that they are expected to perform in every other area of how they deliver responsible, reliable health care. So I have, in this amendment, done just those things. I have enthusiastically added Representative Welper's 24-week limitation, including the possibility of an ultrasound if that is necessary to determine the 24 weeks. But I have added fetal anomalies incompatible with life not just a fetal anomaly, but a fetal anomaly incompatible with life to this. I have added the health of the mother, and I have said, let's not arbitrarily put in here a restriction, and I'm going to stop now because I saw the chair's body language, and he wants me to stop.
Thank
And
you.
I almost always, not always, but I almost always do what the chair wants me to do.
Representative McLean.
Thank you, Mr. Chair. I just had a question for Representative Smith, if that's okay.
Sure.
Of course.
Okay. Well, thank you, Representative Smith, for taking my question. So I think fetal anomalies incompatible with life, in my mind, is something pretty well defined, and I can kind of get my head around it. But you also add an exception for health. And health is not, I think, very well defined. And so because of that, my concern is that it may erode some of the effectiveness of the bill. So did you give any thought to maybe expanding the definition of health, or are you aware of case law out there that basically has already kind of settled down on what that definition is? Thank you.
Thank you. I think it's a legitimate question. If you look, the sentence goes on, it doesn't say just health. It says, then whose life is endangered by physical disorder, physical illness, or physical injury, including, and then it goes on. So that I believe that language
Narrows.
narrows it down. Thank you very much, Representative
Representative
Welker.
McLean, do you like to follow up?
Thank you, Mr. Chair. So in your understanding then, by adding on some of the follow-on definitions that are in there, let's say a woman was to get pregnant, and as a result of that pregnancy, and I'm not a doctor, so maybe this happens or doesn't, she gets severe migraines, but the thinking is that maybe once we go past the pregnancy, those would not be a persistent thing, not something that would not endure past the pregnancy. Would that be considered health, or no? That would be something that this would, in your opinion, not be covered.
Fortunately, it's not my opinion that matters, because what I have stated all along is I am not a physician. I am not a doctor. I am not in that room with the patient. And it would be a medical professional who could say situation X may or may not have been caused by the pregnancy, but has been exacerbated by the pregnancy, cannot be cured or would not disappear unless the pregnancy ends. And that, to me, is a decision that should be made by medical professionals, not by legislators who have all kinds of skills, but no skill in this.
Thank you.
Representative Notter?
One quick comment. Thank you, Mr. Speaker, Mr. Chairman. The
Promoted again.
The abortionists in New Hampshire are not required to be licensed.
Any other questions or comments? Representative Horrigan?
Well, I'm tempted to answer the question about abortionists being licensed, but I guess I'll pass on that one. Obviously, it has to be done. We're talking here about physicians.
The abortionists in New Hampshire.
I suppose there's other medical professionals who might be performing.
pass on.
Anyway, but what I was we're adding the phrase "or health" to the subparagraph 3 in line 28 through line 1 of the first page and line 2 of the second page, and there's existing language that's not in boldface because it's been there all along for those 2 long months since the bill took effect, which says when the continuation of pregnancy would create a serious risk of substantial and irreversible impairment of a major bodily function. It's defined in RSA 329-43 Roman numeral 5, and that's a fairly broad definition of a major bodily function. So pretty much any bodily function is defined as a bodily function. So I've no idea, because that's in the bill. So there already is protection here, and this, I believe, is putting that phrase in is just strengthening it. And there is, we're already we're not putting anything substantially new. We're just strengthening what's already there. And
Thank you.
So,
Other questions or comments? Okay, we're,
Mr. Chairman?
yes,
Thank you, Mr.
Representative
Chairman.
Wolper.
So, I want to start with this repealing of penalties. We talked earlier, and
You need to talk into the microphone, I think, and move it closer.
we've spoken quite a bit today about the value of the life. And when we talk about the penalties that are included in this bill, that's why they're there. Because this is the only procedure we know of, as far as I know, it's the only one that exists, where it involves the intentional killing of a human. And in this case, an intentional killing of a human baby that could easily survive. So there's that. So I don't see, if we remove these penalties, we're devaluing that human life. So that would be my first objection. I agree with the representative from Durham that the qualifications following the words "or health" does narrow that exception. I don't think it narrows it enough for myself to support the bill anyway, but I have plenty of other reasons to not. What I really want to talk about is fetal anomalies incompatible with life, which I don't believe exist in today's medical technology. About 4 years ago, maybe 6 years ago, we had a bill similar to this in this committee, and we had a vice chair of that committee who was, what do I want to call it, very diligently opposed to any exceptions at all. And we spent quite a bit of time talking about fetal anomalies incompatible with life. At that time, the only one that could be identified was twin-to-twin transfusion syndrome. And the reason that no others could be identified is because other anomalies that we normally consider, or did consider even at that time, incompatible with life, were being cured by the technology that we have today. So today, if you have, and I'm not going to try and use the medical terms because I'm not that. So if you have a baby who's getting fluid in the brain and it's swelling and it would kill the baby, today they can go in and withdraw that fluid, and that baby can proceed through its more normal course of pregnancy. If you have a baby with an open brainstem, they can go in, they can take the womb out, open the womb, perform surgery on that baby and close those openings, and the baby can continue. I'll go back to twin-to-twin transfusion transfer syndrome. For those that don't know, that consists of when there are two babies in the womb and they share the blood supply. So one baby gets more, one baby gets less. That's just the way it works. And that would be fatal to the one that gets less blood. Except, even at that time, and this is several years ago, at the Cleveland Clinic, the survival rate of both babies was over 20%. The survival rate of one was way over, not 80%. And I'm quite confident that their technology has improved in the years in between. So I don't believe there's actually any fetal anomaly that's incompatible with life. So I would ask the sponsor to identify one or two.
Thank you for the question. And I would say if there is no fetal anomaly, what's the language? Incompatible with life, then that language doesn't matter. But since I have no way of knowing that because I am not a physician, I am not a geneticist, I am not technically skilled in any of those decisions, I believe that that should be left for medical professionals. And I do know that that's where those decisions should be made. If we have the most wonderful medical system and there's never an opportunity for a fetal anomaly that cannot be corrected, so be it. That's fine. Then nobody can fall under this. But I think it's likely, Representative, that there are fetal anomalies, and I want to make sure that women and their families are protected in that situation.
Follow up?
Can you follow up?
So, we already know that not all abortionists in our state are required to be licensed. But even beyond that, it's my understanding that typical medical practice, if a doctor performs an operation and the patient dies or there's death involved, that there's an autopsy to determine if, in fact, the diagnosis was accurate and what the doctor did was correct. How do we know that anybody who wants to violate the 24-week abortion ban couldn't just claim that there was some fetal anomaly incompatible with life, right? And that's what they'll put in their fetal anomaly incompatible with life. How do we know that there actually is such a thing in the case where the law is violated?
I guess I can't answer that question. I'm not going to go through, the looking glass with you and say, what if, what if, what if? We live in a world in which sometimes things happen that not one of us would tolerate or want or expect. What we're doing here is trying to pass reasonable legislation that in fact honors our commitment to law, to medical standards, to all kinds of behavioral limitations, and respects the right of a woman faced with a difficult situation to get the best professional guidance she can in making a decision. And do I think someone might be outside there right now, breaking into my car? Of course somebody might be. Can I control that? Well, no, but there are laws to make sure that if they're doing that and they get caught, they can be held responsible. And it's certainly the same thing holds true whether you're a bricklayer or an obstetrician or even a legislator. No, that's not true. We're exempt from so many things. I think, truthfully, I'm not going to answer any other questions because I'm afraid that the chair is really going to get annoyed with me, and I would never want that to happen.
So, last statement.
Representative Wolpert, you want to just follow up with the last
So,
statement?
what I get from that is that we have created an opportunity here for anyone who so desires to violate this bill with no accountability, because there's no check on whether or not the reason given is in fact true, and no penalty even if it is true. I mean, even if it's not true, which effectively makes this a useless piece of law. So I'll be voting against the amendment.
I'm surprised to hear that, Representative.
We don't need the comment. So, Representative McBath.
Thank you, Mr. Chairman. I'm shocked at the statements that I've been hearing that a couple of my colleagues have made, that there is the unauthorized, unlicensed practice of medicine going on in New Hampshire. And I'm not sure if they're talking about the dispensing of a morning after pill by someone that it's not, but to say that if that's occurring, I think that that's an issue for, I mean, if people are illegally practicing medicine, I think that those colleagues should bring that forward. And if not, that is really an outrageous claim, and I'm concerned about the misinformation that people that might be hearing and listening to this might think about New Hampshire and about our laws and the operation of this committee. If those comments keep being made without being challenged or asked, at least some other time, this might not be the right time. But I just think those are spreading of misinformation is wrong.
Thank you, Representative Almy.
Thank you. I think what your colleagues are saying is that they are not licensed specifically to do abortions, but they are obstetrics and gynecology licensed doctors. The law that was passed directly affects our ability to have gynecology and obstetrics doctors in this state. I am from Lebanon. Lebanon is the center of Dartmouth-Hitchcock. My father helped restart the medical school many years ago. They can, if they are told that if they are faced, well, let me go back a second. We have lost most of the OBG doctors outside of major medical centers in this state already. There are too few babies being born. They have had to consolidate into major centers. If a woman is having major trouble with her pregnancy, she gets bumped up from Berlin to Lebanon, or from Berlin to Concord, or someplace like that. If they are having a major problem and they land at the desks of the top OBGYN people in New Hampshire, which is what usually would happen when it's a major problem and urgent, that doctor is faced with, in some cases, very rare cases, but they are faced in their practice with, am I going to allow this woman to die, or am I going to do an abortion? And you try recruiting people to come and join the few OBGYN doctors we have in this state when that is hanging over them. What we're doing is making sure that women are not going to have adequate OBGYN care if we keep that on the books. Thank you.
Representative Notter.
Thank you. It is true that in New Hampshire there is no law that says that an abortionist has to be licensed. So maybe that somebody wants to put in a bill to fix that, to make sure that they're licensed. My second question is for Representative Wolper. Is everything that you were describing, like the worth of a person and what's an anomaly, whatever, does that fall under the category of eugenics?
Well, it does, it could. But in the context of this bill, I don't believe it does. Unless you say that Down syndrome, which is was being more or less successfully eliminated in various countries by the process of abortion, if you consider that to be a fetal anomaly incompatible with life, or for somehow or other falling outside the scope of this, then it would, but there you go.
Okay. Representative Horrigan.
Yes, well, maybe I don't need to beat this dead horse, but there are, the law does apply to anyone who does an abortion regardless of whether or not they're a licensed healthcare professional, but as others have pointed out, you definitely do need to be a licensed physician or an allied profession, and you do need to be, and you do need to be certified, so it is illegal to practice medicine without a license. The best I know, and I don't. There isn't a specific. I'm pretty sure it probably is correct that there isn't a specific chapter of the RSA's about abortions, but that'd be subject for another. Oh, was I going on too long? And also, yes. So anyway, neither the hospitals nor the smaller reproductive health facilities. I can be quite certain that none of them are having unlicensed professionals provide surgical services such as abortion or any services, that they're all properly licensed and certified, and it would be.
Okay. We've had a pretty good discussion. Are we ready to vote? Okay, this is on the amendment. This is on the amendment 0730, offered by Representative Smith. Mr. Clerk, do you want to call the roll?
On the acceptance of Amendment 0730 to House Bill 1673, Representative McLean.
No.
Representative Sylvia.
Oh.
Representative Walper votes no. Representative Alexander.
No.
Representative Green.
No.
Representative Nodder.
No.
Representative Murner.
No.
Representative Kelly. No. Representative Doucette.
No.
Representative Andrus.
No.
Representative Smith.
Yes.
Representative Almy. Representative Horrigan.
Yes.
Representative DiLorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson. Mr. Chairman,
Yes.
2, 4, 6, 8, I have 11 in the positive, and 10 in the negative.
You've adopted Amendment 0730. And is there any other discussion on the bill? We've had a pretty thorough discussion here. If not, you could call the roll. This is on the motion of ought to pass as amended on House Bill 1673 with Amendment 0688 and Amendment 0730.
So just a question, Mr. Chairman.
Yep.
Since Representative Smith and Simpson authored the sponsoring amendment, can we call this ought to pass as amended by them?
You can, and I definitely will have Representative Smith do the majority report on this. And have Representative Simpson do the PI if that should be necessary.
On the question of House Bill 1673, ought to pass as amended with Amendment 0730. Representative McLean.
No.
Representative Sylvia.
No.
Representative Walper votes no. Representative Alexander.
No.
Representative Green.
No.
Representative Nodder.
No.
Representative Murner.
No.
Representative Kelly.
No.
Representative Doucette.
No.
Representative Andrus.
No.
Representative Smith.
Yes.
Representative Almy.
Yes.
Representative Horrigan.
Yes.
Representative DiLorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
I have an 11 in the positive, 10 in the negative.
And Representative Wolper, would you like to do a minority report?
It would be, yes, sir. Yes, sir, Mr. Chairman.
And that would be ITL?
That would be ITL. No.
Oh, it would be
OTPA
OTPA, yeah.
with my amendment.
Okay, is there any other business that we need to address here today? I'd like to have everybody do their majority and minority reports by next Wednesday, if that would be okay. If I could get it by Wednesday. I had everybody do them very quickly the last time because I thought we'd get them all on the calendar, and of course, they didn't get in the calendar, so. But I think if I got them by Wednesday, we could have them done by, and submitted by the end of next week.
Do you have any word on when we're likely to be meeting again and where?
I heard the second week in March, but I don't have a specific date, and I suspect it will be back in Representative